This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why sloth in litigation is fatal to your case, and there can be no UM or UIM coverage supported when there is a denial that starts the running of the statute of limitations and that statute is ignored. In Glenna L. Novak and Estate of Jeffery Leonard Novak versus Mutual Benefit Insurance Company, an October 14, 2022 decision of the Superior Court of Pennsylvania, when the plaintiff's lawyers admitted a letter from the insurer was a denial of a UM-UIM claim, that denial started the running of the statute of limitations. Glenna Novak and the estate appealed from the order granting summary judgment in favor of Mutual Benefit Insurance Company, MBIC, because of the running of the statute of limitations. In June of 2011, Jeffrey Leonard Novak, the decedent, was operating a motorcycle when a vehicle driven by Roy E. Wright made a left turn across decedent's lane of travel, causing the motorcycle to strike the vehicle. The decedent was thrown from his motorcycle and sustained injuries, including severe head trauma, which resulted in death. The appellants sought recovery from Wright, who had an insurance policy through a Progressive Specialty, PSIG. Wright's policy had a bodily injury limit of $50,000, which PSIG tendered. Appellants also submitted a claim for underinsured motorist coverage under decedent's motorcycle policy. The motorcycle policy was issued by Progressive Advanced Insurance Company, PAIC, who informed the appellants that decedent had rejected UIM coverage. Appellants sued, contending the UIM rejection was ineffective, and they eventually reached an agreement to resolve the suit for $20,000. Appellants' counsel wrote to MBIC, which had issued insurance on two of appellants' other vehicles, a car and a truck, seeking consent to settle the two claims. In a letter dated October 3, 2012, MBIC stated the motorcycle the decedent was driving at the time of the accident was not insured by MBIC, and therefore MBIC explained UIM coverage was not available under its policy and its consent was not required for settlement. Appellants later made a claim to MBIC for UIM coverage under the personal auto policy. MBIC denied UIM coverage, stating it had previously denied coverage in the October 2012 letter, which had explained that its consent was unnecessary for the settlements. Appellants sued in February of 2018, 6 years after the first denial, and they filed a complaint in May of 2019. They alleged breach of contract, sought a declaratory judgment, and requested damages for bad faith. MBIC filed a motion for summary judgment, arguing in part that appellants' claims were barred by the statute of limitations. The court, in analyzing the issues, noted that the appellants maintained the accrual date for the action could not have occurred before August of 2017 when they submitted a UIM claim to MBIC. Appellants contended that an unsolicited opinion or observation by an insurer that it may or may not have coverage applicable to a particular matter is different from an insurer processing a claim affirmatively stated and submitted by an insured to the insurer for action and denying the insured the specific benefits claimed. Unfortunately for the plaintiffs, and the appellants, Pennsylvania law provides for a 4-year statute of limitations on breach of contract actions and related declaratory judgment actions. In this case, the trial court concluded that the limitations period began to run when MBIC denied coverage in the October 2012 letter, and therefore the current case, commenced in 2018, was barred by the statute of limitations. The appellate court concluded that it cannot be genuinely disputed that MBIC denied coverage of the subject accident by letter dated October 3, 2012. Although appellants had not yet made a claim under their MBIC policy, a plain reading of the 2012 letter made clear that MBIC was denying coverage for the subject accident. In order to file a timely breach of contract claim, appellants should have filed their action no later than October 3, 2016, which they did not do. Therefore, the Court of Appeal concluded that appellants' claims were untimely and summary judgment should be entered in favor of MBIC on all claims. The October letter stated that UIM coverage is not available under the policy. Even appellants' counsel admitted that upon receipt of the letter in 2012, he interpreted the letter as a denial of coverage, and therefore the record supported the finding of a concession by counsel and an obvious failure to sue timely, which of course defeated the suit. In my opinion, when the lawyer for the plaintiff concedes that there was a denial in 2012 and the suit was not filed until 2018, he conceded the statute of limitations applied and the suit was untimely, probably because he agreed there was no coverage under the MBIC policy even if they had filed timely. When a plaintiff has a viable cause of action against an insurer, there is no excuse for failing to sue within a 4-year statute of limitations. Of course, the plaintiffs are not without a remedy. If the failure to file timely was the result of poor advice from counsel, the plaintiffs can always sue their lawyers, but it will probably not succeed. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on zelma.com/blog, and is also in video form on rumble.com and on youtube.com. If you're watching this video on YouTube, please click on the like button, and if you're watching it on Rumble, please click on the Rumble button. Please also consider subscribing to my locals community and to my Substack publications. Thank you for your attention.